Hi, my name is Jeff Sines, and I'm an associate attorney here at the Vethin Law Firm in our San Antonio office. And I'm here with Steve Costello, and we're going to talk a little bit about the discovery process and spoliation of evidence. Right, and you usually want to notify the other side of that duty to preserve evidence. And what that does, upon receipt, now they're on notice of that duty, and any subsequent spoliation could provide evidence of bad faith. And what is spoliation now? Spoliation is the withholding, alteration, or destruction of documents or evidence that is material to the lawsuit. And certain consequences can come from such destruction.
What happens if a party is found by the court to be guilty of spoliating or destroying evidence?
So there are two main punishments that the court could give. First could be sanctions, and that's usually just seen in attorney's fees. The party that spoliates or destroys the evidence will be responsible for attorney's fees. The second, which is the harsh punishment, and that is a jury instruction. So it's called an adverse inference instruction, and what happens is that basically the judge tells the jury, you can go ahead and assume that the evidence that's lost or missing or destroyed was going to be detrimental to the party that lost it. As I said, it's a very harsh remedy, and oftentimes it's dispositive to the outcome of the case.
Meaning that a jury's decision could be determined by a jury instruction, an adverse jury instruction. So an important question is, how do Texas courts handle making a decision of whether evidence was altered, destroyed, withheld?
Recently, there was a big, within the last 5 years, there was a Texas Supreme Court decision known as Brooks Brothers versus Aldridge, and some pretty important case law came out of that.
In that case, the Texas Supreme Court held that in order for a spoliation instruction to be an appropriate remedy for a jury to consider, the court had to determine that the spoliating party, that is the party destroying, altering, or withholding evidence, had done so intentionally. The Texas Supreme Court did carve out a narrow exception where negligently spoliating or destroying evidence could still lead to a spoliation instruction, but that's only in the case where a party's defenses or claims would be meaningfully affected by that negligent spoliation.
So we learned about the instructions. So what are the practical implications, and how do you take this back into your practice?
Right. Well, we already talked about the preservation letter. That's very important. So if you're a party filing a lawsuit or intending to file a lawsuit, it's very important to serve a preservation letter on the opposing party. That creates a duty with the other party to preserve the evidence. Mm-hmm. So it's also important for Texas businesses to have document retention policies and procedures in place in order to protect themselves.
That's right. For more information on the discovery process, the spoliation of evidence, or other complex legal issues, please come visit our website for more blogs and videos at vethinlaw.com.